All right, good evening and welcome. This is a public hearing of the Zoning Board of Appeals of the City of Evanston. The zoning ordinance directs this body to hear applications for major variations, special uses, and appeals from decisions of the zoning administrator. Depending on the type of matter, this board will either make a final determination or send its recommendation to City Council. Melissa, will you please call the roll?
Mary McCauley,
Present.
Lisa Deacon,
Here.
Scott Gingold,
Here.
Mary Beth Burns,
Here.
Violetta Cullen,
Present.
Mirna Aravallo, Kirill Miranchev.
Here.
And with 6 members present tonight, we do have a quorum. We also present tonight are zoning planner Melissa Klotz, planning and zoning administrator Scott Mangum, and the assistant city attorney Mario Tretto. This is a formal meeting, and there are rules that govern our proceedings. Most importantly, only one person speaks at a time, so all testimony may be accurately recorded. Anyone who wishes to address the board regarding any matter on the agenda will have the opportunity to do so at the appropriate time. Our procedure is to hear from staff on the documents on file and then receive testimony and other evidence from the applicant or appellant. Next, persons who wish to make a statement regarding the matter may do so at that time. Any person with a legal interest in property located within 500 feet of the subject property may present evidence, reasonably question witnesses, or seek a continuance of the hearing. When all supporting and opposing testimony and statements have been heard, the applicant or appellant will be given the opportunity for rebuttal or a closing statement. Then the board will close the record and begin deliberations. All testimony will be under oath. Although we do not apply the strict rules of evidence, please limit your testimony or statement to your personal knowledge. When you address the board, please state your name and address and sign in on the provided sheet. Our meetings are audio and video recorded. Please make sure that you are at a microphone when asking questions or making statements so that they can be properly recorded. All proceedings are subject to broadcast at a later date. Any matter not concluded at tonight's hearing will be continued to our next regularly scheduled meeting. There is only one item on the agenda tonight, and it is a continuation from our last meeting. I see that the applicant is here as well as the neighbors. So what we're first going to do is anybody who plans on speaking tonight who wasn't here at the last meeting and didn't get sworn in, please raise your right hand. Do you swear or affirm to tell the truth throughout the course of these proceedings? I do. Thank you. All right, so are we doing minutes? I don't think we're doing minutes.
I've got them on the agenda.
Oh, we're doing minutes. Sorry, my apologies. So we're going to start with the approval of the meeting minutes of January 9th, 2018. Has everybody had a chance to read those?
Yes.
Any changes? No? So a motion?
I'd like to make a motion for the approval of the meeting minutes of January 9th, 2018.
Second.
It's been moved and seconded. All those in favor say aye.
Aye.
Against? And I will note that those not voting were not present at that meeting. Now, back to 2626 Reese Avenue. We do have one board member here with us here tonight who was not at the meeting last week. Have you had a chance to review the testimony and the documents on file?
I have.
And so you are fully up to speed and capable of rendering judgment on this case?
I am. Thank you.
Thank you. All right, so we're going to start where we ended last time, which was with neighbor comments. So.
Wait, let me interrupt you for a second.
Yes.
Just to add in for the record, there was a bit of material passed out at the beginning of the meeting. There was a document from the applicant from Second City Appraisal, as well as a copy of the plat of survey of the property. And there was a letter passed out from a neighbor, which was the transcript of what he said at the last meeting that he felt was not accurately reflected in the minutes. And I also have a copy of one other bit of testimony from a neighbor from a previous meeting, but I have just one copy of that one that was just submitted as part of the record.
Thank you. So we're going to go back to neighborhood comment. So if you...
Mary Beth,
Yep.
just a point of clarification
Sure.
as to process this evening.
Yep.
My understanding is the intention is that those neighbors that did not testify last week but are joining us this week have the opportunity to testify as well as if there's any new testimony from those that were testifying last week. So
That's correct. That's correct. And then after the neighborhood testimony, then we will give the applicant a chance for rebuttal. And then we will close the record at that point and go into deliberations. All right. Everybody comfortable? Great. So who would like to, is there any neighbor who would like to speak this week? You can come up and give us your name and address. And we do ask that you limit it to completely new testimony, right? Thank you.
My name is Richard Horsting. I live next door to the property that is being looked upon here. What I have come up with, again, if I have to remind the people here at the court or this board here, I'm one of the oldest family members as far as in the city of Evanston. I came across an original 1925 Plata survey here that the city doesn't even have. This is before the houses were built. It shows my house that was owned by the Moore family, the lot, without being built yet, and the corner lot. This Plata survey was ordered by Cairo Building Material in 1925. To give you a little history of Evanston, which I probably have more than most people here, these lots were sold for $100 at the time, and most of these building material companies purchase these properties because they use it as not only a dump site for all the used material, but I also have 6 photos, 5 my attorney has right now, but I have one here showing the mounds and mounds of debris from the 50s that still existed from people depositing materials. Now, if you remember anything about the history of Evanston, all of our pipes and that infrastructure there are mostly lead lined. I have, when I gardened there, I gave up because in 2001, the soil samples that I have, which I do not have here, but I have on record, were tainted. My neighbor and I, Jeff Clark, stopped gardening there, but he will also testify that if you dug 4 or 5 inches down on this lot, there's nothing but debris, from knob and tube wiring to galvanized pipe to glass. And if you know how lead pipe was done back in the 20s, 30s, and even into the 40s, it was usually soldered with lead. If this building does go through, which I absolutely do not want to have happen, I'm going to want soil samples done to collaborate the problem this man's going to have of how he's going to remove all of this soil. I know the EPA a little bit. I know what the gas station had to go through with oil spills at the corner of Central and Reese. He spent over $250,000 having to excavate a spilled oil tank. And I know what would happen here if he digs down. He's going to have to get rid of that soil and do it through EPA standards. And the disruption of that will be a complete disruption to not only the building being built there, but my safety and health. Thank you very much.
Thank you.
May I ask a question, sir?
Sure.
Do you know if any core samples have been taken of that soil?
Not core samples, soil samples. And my neighbor, Mr. Jeff Clark, will testify that when we gardened over there, if you dug down 4 to 5 inches, you had to stop because of the amount of shards, pipe, glass, knob and tube. Everything is in that whole entire lot. Not only next to my house, but basically the entire lot. And anybody who wants to dig there, I'd be glad to let them go and dig. But you have my sworn testimony that I gave up gardening there, and I'm sure Mr. Clark will collaborate on that as far as when he gardened there, too, the amount of issues we had digging up debris. If you look into the records of Cairo Building Material and the history of Evanston, that's what these corner lots are used for, because it was only $100. It was a 25-foot lot. As a contractor, myself, we don't have the excavation materials in 1925 that we do today, earth moving equipment and everything else. So this was an easy way for them not only to dump supplies to build on, but also to get rid of all the excavation materials that were used in the city. So I have all records on file. My attorney has them too. Thank you.
Kathy Miller, 2831 Hartzell. I spoke last time, and I have 2 items. I'm glad that Dick brought that up, because in one of my letters that Melissa has, it mentions my concern about lead levels and the fact that there should be soil sample testing. Oftentimes, that's required in certain communities. I wanted to enter into the record neighbors who have not been able to be here, but in the previous when we had the previous owner who withdrew her application 3 hours before, we had sworn testimony, and we've gone around during the cold, et cetera, and with emails. So I'd like to give you the map of the neighborhood opposition, and so you can see the actual plat of the neighbors.
To clarify, then, this is not opposition to the current proposal, but to the...
It is for the current proposal.
Oh, for the current proposal.
Now for the current proposal.
So I would like to mark this as Exhibit C. I think we're on D.
Yes.
We're on Exhibit D, and I would like to clarify what we're actually looking at. This is a neighborhood map for all intents and purposes. Some of the houses are colored in blue and some are white. So the legend is that opposition is blue and that white is either non-opposition or no response. And when was the date at which you received the notification from these neighbors that they were in opposition?
After
You need to come back up to the microphone, please, so we can record you.
After your notice, original notice in what was that, October? And this is an ongoing, many of these neighbors have been in opposition for quite some time, but this has been since the first notice of the meeting that was postponed. Since then,
But this is a map showing opposition to the proposal that was be presented in
proposal
October.
now.
This is a map showing opposition to the proposal that was to be presented in October, correct?
And since, because everybody has gotten all the packages and everything that Melissa has, so no
when was
one
the
has
map
withdrawn.
created?
The map was created day before yesterday.
Okay, when was the data for this map collected?
It's been collected since the October meeting, but everyone has had all of your materials and no one has withdrawn. As a matter of fact, there are other people who would be on here, but it's cold, it's freezing, and I don't have every email in the neighborhood.
Understood.
So,
Thank you.
you're welcome.
Thank you. All right.
Hi, Tom Sufferton. I live at 2334 Ridgeway. So I'm not nearby, but it's relevant because I'm the alderman for the 6th Ward where this property is. I would like to first say that I think that Mr. James did a commendable job of soliciting neighbor input. He reached out to me very early in the process. That being said, it's also pretty clear that none of the neighbors support this project. I haven't heard from anybody that supports this project. I didn't intend to come and appear before you. I watched the meeting last Monday and kind of had hoped that there would be a resolution then. But I feel like I have an obligation as an elected official representing the neighbors to just ask you to take into account, to the extent appropriate, the fact that there are no neighbors who've reached out in support of this to me and nothing but vehement opposition from the neighbors. Thank you.
Thank you.
Hi, I'm Kim Newman, 2833 Hartzell. When the builder was talking last time, he was saying he didn't feel there was a need for small 2-bedroom, 1-bath houses. I feel just opposite. If you want Evanston to have young families and have turnover, it's just what we do need. It's a small lot, a small house. I think it would sell in a minute. A lot of us have dormers and eaves with bathrooms and bedrooms. And I don't know about you guys, that's what we started in. Our house has grown since then. But I really feel this would be a perfect lot to have a starter house and get a young family in Evanston. And the neighborhood's turning over, and I just think it would be really nice to have more kids and more families.
Thank you.
Hi, good evening. My name is Andrew Niddick. I live at 2619 Lincolnwood Drive. Thank you so much for these proceedings. I wanted to underscore a point that's come up, which is that a smaller house wouldn't be saleable on the lot. This council has previously heard that no smaller home would be saleable, and that's patently false. On December 22nd, my wife had a conversation with the builder where we clearly stated our longstanding desire to build or buy a sort of mother-in-law or 12-foot wide New Orleans shotgun house on that property, which wouldn't require much of a variance, would preserve most lot, which would preserve the line of sight to the alley where my young children, and many people's young children, like to race in and out around the corner, looking around for the commercial traffic that's already there. I lived in New Orleans shotgun when I did my training in New Orleans, and it would fit very well on the property. We reiterated our desire to buy one or to buy the lot and build one ourselves. So the idea that a small property wouldn't be viable or wouldn't be saleable is patently false. I stand here before you today, we would be ready to move forward if that opportunity were to arise. I was not previously aware of the issues with the soil as presented by the neighbor to the property. As a professor of neurology at Northwestern's medical school, I'm very sensitive that once you start digging things up in the soil, particularly lead, other heavy metals, and other divalent cations, this leads to a host of neurological problems which can be long-lasting, take years to develop, are difficult to test for, and have long-lasting sequelae on the health of adults and children, leading to expensive testing, extended evaluations, and both mental and physical and cognitive disabilities.
Thank you.
Thank you.
Hi there, I'm Liza Kirkpatrick. I live at 2904 Hotchkiss Street. Thank you for these proceedings. I wanted to address a comment Mary Beth Burns made on January 9th. Thank you for this. What we heard was it's not specifically against the rules for granting a variance to allow somebody to make a profit. However, when there is a profit to be made, there must be public benefit. So the burden falls on him to prove what public benefit is. So we went back and we looked at section 6363 of the zoning regulations, and it provides 9 public benefits that are intended to be derived from the approval of planned developments. And so I have a list of what those 9 are, and then is there an actual public benefit in this case, 2626 Reese? And I'll go through a couple, and then I will submit this to you guys to look at. But the first one, intended public benefits. The statute says preservation and enhancement of desirable site characteristics in open space. No, this development does not preserve or enhance open space. In fact, open space is virtually eliminated. B, the statute 6363, a pattern of development which preserves natural vegetation, topography, and geological features. No, in fact, the plan considers the elimination of all natural vegetation as a benefit, and so on through the 9 different points. The section E, and this is one that I want to point out that ladders back to another neighbor's comment. Provisions of a variety of housing types in accordance with the city's housing goals. If we look at the proposed 2626 Reese and look at the city's 2018 City Council goals include expand affordable housing options. In the meeting that we had on the 9th, the builder testified that this development will not meet the definition of affordable housing. And I think that there's a real willingness to look at some development on that site. Granted, didn't know about the lead issues, but that would be reasonable and in keeping with the rest of the neighborhood and the rest of the immediate neighbors. What has been presented, not only by this owner, but the previous owner, is something that is so outscaled that it has gathered the intention of the entire neighborhood. So I'd like to present this document that reviews.
Thank you. We're going to enter this in as Exhibit E. And this was assembled by you?
Assembled by me.
Okay.
My husband.
Yep.
And it does have coffee stains on it. Apologies for that.
Okay.
But thank you for letting us present that.
Thank you.
I am William Sile at 2835 Hartzell Street. And based on everything that we heard last week from people who were presenting in opposition, we would now like to look at the standards that have to be met for approval. Standard number 1 regarding the use, enjoyment, and property values. Last week we heard testimony from 3 property owners directly to the south of 2626 Reese, from the owner directly across the street to the east, from the 2 property owners directly to the west, and with my appearance here tonight, now all 5 property owners across the street to the north, across Hartzell Street. All of us are testifying to a concern that our use, enjoyment, and property value might suffer. However, as we understand it, this process is designed that we are not required to prove any suffering on our part, rather that the applicant bears the burden to demonstrate that the proposal meets each of the standards. We have not seen any actual demonstration that this first standard has been met. Standard number 2, regarding keeping with the intent of the zoning ordinance. We have noted that the intent as stated in the ordinance includes minimizing or lessening congestion in the public streets, preventing the overcrowding of land, and regulating and limiting the intensity of the use of lot areas. We would submit that the application for 2626 Reese flies directly in the face of those 3 components of intent. Standard number 3, the alleged hardship or practical difficulty is peculiar to the property. We can agree that the conditions of lot width and size are peculiar to the property. And we can agree that the alleged hardship is exactly what it says, that being not an actual hardship, but a hardship that is only being alleged. We would say that the peculiar characteristics of the property are not inherently a hardship. They can become a hardship if the ambitions of ownership exceed the capacity of the property to deliver. A modest ambition for an unpretentious strip of land is not a problem as we see it. Standard number 4 regarding how an owner might suffer if the strict letter of the regulations were to be carried out. If the strict letter of the regulations were to be carried out. Is that what we're talking about here? If you want to reduce a 13.5-foot requirement down to 1 foot, it's our feeling that you left the strict letter of the requirement behind a long time ago. We would ask that we keep the discussion of this standard within the domain of the strict letter of the regulations, which allows for variations minor and major, but not unconscionable. Standard number 5, requiring that it not be exclusively about extracting additional income. In these chambers last Tuesday, we were informed from the chair that you're allowed to make a profit not only when but only when there is also public benefit. In the application, we find 3 different claims for meeting the standard. 1, the purpose is to allow the lot to be used for residential purposes. 2, he's only going for the minimum financial gain. And 3, the proposed house is the smallest practical house. We don't see any public benefit in these claims, certainly not as public benefit is described in section 6363 of the ordinance. Standard number 6, the question of self-creation. Having sat through more than 4 hours last week of zoning business, we started to realize that within these walls, the concept of hardship is more associated with the property itself than with the free will of a speculator. And it seems to be taken for granted that if a speculator wants to buy a property on which nothing can be built in accordance with the zoning ordinance, and then claim that to be a hardship, that makes perfect sense. But as lay people who don't deal with these issues every day, nothing looks more like self-creation than to buy something you know you can't build on, and then claim that it's not your fault, and then demand that the surrounding community underwrite the gamble that you made by putting their use, enjoyment, and property values on the table. Standard number 7, requiring the least deviation from the zoning regulations when choosing from the feasible options. Well, maybe it depends on what feasible means. In this case, we're asked to believe that feasible means the least profitable way to build on this property. Speaking in opposition, we are hopeful for a decision that is consistent with the full purpose and intent of the zoning ordinance, in which conserving and enhancing the taxable value of land is only one of the 11 stated intentions. And we can wish for a decision that might balance the taxable value of land against other stated intentions, such as promoting the public safety, comfort, and general welfare, lessening the congestion in the public streets, preventing the overcrowding of land, establishing and regulating the setback lines, limiting the intensity of the use of lot areas, and prohibiting structures that are incompatible with the character of established zoning districts. Thank you.
Thank you.
Jeff Barkley, 2622 Reese, so just 2 properties to the south. My wife took the petitioner's first floor plan and put it into AutoCAD to look at the numbers that were the building lot coverage in relation to the front porch that was much talked about last week, with and without the front porch. And what she found was that the Dapper number was 37.9% lot coverage. And in both cases, with or without the front porch, she came to 38.5% and 38.12%, which are both over that 37.9% number. And if I could just...
Sure. We're going to mark that as Exhibit F.
The only other thing that I wanted to talk about was property values. So when we walk out in our backyard and we look to the north and we look to the south, all that we see is trees and backyards. All the properties along Reese are in line with one another, and it's clear by looking at the plan that's put forward that this new property is going to extend far into our backyards and loom large over our properties. And so all I can say is that when you talk about something having a negative effect on our property value, there's no question that if this property goes forward and is built, that we'll just see a large wall running along our backyard property. And, there's no question that that will have a negative impact on the value of our property. And I think a lot of other people have covered a lot of other things that I wanted to talk about tonight, so I'll just end it there. Thank you very much.
Thank you very much.
Yep.
I think, given that you've provided a document, I think I'd like to have Melissa just briefly address your concern.
Yep.
So it looks like the discrepancy in the building lot coverage is likely due to a couple different things. Number one, the bay window. Since the bay window does not go all the way down to the ground with a foundation, that is not counted in building lot coverage.
Okay.
So that's roughly 10 square feet. And then the porch, the roofed portion of it only counts at 50% of the total size of it based on the code. So I think it's between those two things that we've got the very slight discrepancy in the calculation.
Okay.
And we just want to make sure that everybody understands how we come to these numbers and that we're as transparent as possible with, and that you understand how the numbers are arrived at.
Right.
And we're not anything. All right. Thank you very much. I appreciate that.
Hi, I'm Beth Parody. I live at 2907 Hartzell Street. I realize that your concern is with ensuring that the developer meets the standards for a major variance and not whether he does high-quality work with an appealing aesthetic. So tonight I want to address just the standards for a major variance and how they've not been met.
Sorry, ma'am. You're certainly entitled to talk, but if you're going to repeat the points that another neighbor has made, can you please just try to indicate you agree and move on to something that's new so that we don't spin the same wheels on the same points?
Absolutely.
Okay, thank you.
So let me see. Just want to make sure. So the first point I'd like to make that he proposed multiple options, all of which were the same size, specific size configuration, and one that's larger than almost all the other homes in the area and on the smallest lots. So that will add to the support for profit motive, and to that point as well, it's in direct conflict with Rule 63812E, Item 5, regarding the no valid public benefit. Let's see, again, I'd like to reiterate that I do not feel he was not forced to buy the property, so it is not, it's his own, he created his own hardship. Another point I'd like to make, one that caused me to come to speak, is he testified that the neighbors at a June meeting were opposed to all plans. I was one of those neighbors, and that is not the case. As you've heard here, we all oppose appropriate, smaller building on the property. So he has not demonstrated with Rule 63812E, Item 7, that he's requested variations are by no means limited to the minimum change necessary, since it is possible to build a smaller property. Also pointed out that he was addressed about building a smaller property and turned down, as Mr. Nidich has testified. Lastly, I'd like to point out that as part of his testimony last week, he was comparing his proposal to existing lot coverage in the neighborhood, and that is misleading and demonstrably false, because basically he's comparing to houses that were built around 100 years ago. And so if you think of it as somebody proposing a rule for a new car with leaded fuel, no seatbelts, and no airbags, just because cars were sold that way 50 years ago, it's a similar thing. What he's building today should not be based on what was built 100 years ago. And basically, I just wanted on record that I respectfully request that the Zoning Board of Appeals reject the application. Thank you.
Thank you.
Hello, my name is Brody Austin. I live at 2620 Reese, which is 3 doors to the south of the proposed development. Just in the interest of keeping things concise and to the point, I just wanted to express 2 concerns that I have and why I would like for you to reject this proposal, and why, as many of my neighbors have expressed, that we are in favor of something smaller and more modest that doesn't go to such extreme lengths to request so many variances. We don't live on a sleepy little block that's tucked away into a back corner of Evanston. We are about half a block away from a fire station. And while my children thrill to see the fire trucks going up and down our street, there's a lot of traffic. We also have a lot of the parking from local businesses. People seek parking on our street. And so there's a lot of traffic there. And so the reduction in sight lines that the variances would cause at the corner of the block are of serious concern to me and my family. I have 2 small children, and as has been mentioned, we ride our bikes on our sidewalks in the street. We ride our bikes in the alley, and so the reduction of sightlines is of serious concern to us. Another thing that I just want to point out too is the increase of impervious surface on that block. We already have a number of houses that are very close together. We already experience significant drainage issues and flooding issues. When there's a lot of moisture in the area, our sump pump is running continuously. And by removing even that sliver of land, I am, don't want to consider what the environmental impact of that will be with increased drainage problems around our property. So again, this is just to kind of highlight some of the adverse effects that we see being caused by the extreme variances that are being requested by the developer. Thank you.
Thank you.
Hi, I'm Nancy Crane. I live at 2821 Hartzell Street. I've lived there about 30 years. I'm kitty corner from the proposed construction going on. My neighbor previously addressed something, so what I wanted to bring up was that, in fact, about getting water in our basements as a result of the new construction and as a result of less drainage in the area. Right now, things are pretty good. Most of us are doing pretty well on not getting water in our basements. I don't think there's any kind of guarantee, but I would love it if he does this, we won't start getting water in our basements again, either with the construction or with this taking up all the space and all the green space. Thank you very much.
Thank you. Anybody else? Last call. All right. Okay, so neighborhood comment time is now over. So, sir, you are welcome to come up and address the neighbors' concerns. We ask you again to try to limit your testimony and your comments to either addressing their concerns directly without being repetitive.
So, I did, in the interim period of time, consider the comments that were made prior to this evening at the last meeting, both the neighbors' comments and comments that I heard from the ZBA members, which I'd like to address. So those are the 6 points identified here, and I don't have a clicker here. Do I?
Next shelf down, sorry.
Okay. All right. So I'd like to talk about other options, other designs that were brought both by the neighbors and by the ZBA members, the impact on value of adjoining property. A question was raised, when were these other homes that I made reference to in prior presentation, when were they built? I'd like to address the financial feasibility of a smaller house, the ones that the neighbors had made reference to, and impact on flooding. Those are the 5 points plus a summary. So, as a designer, and I believe the architects on the ZBA, you know that there are a lot of different options. There's not just one way to do anything. In formulating this plan, as I mentioned before, my objectives were to minimize the number of variances and the degree of variance. So, for example, height was not a variance I was asking for. It was not something I was trying to minimize. Interior side yard was a potential variance that I avoided asking for by virtue of the design of this house as a 16-foot wide house. I also wanted to have as much street side yard as possible, and so all of these things factored into the creation of this design. Now, if one wanted to pursue other objectives, for example, the question of, well, what about a house that was a story and a half high? Yes, that would be possible, but you would have to have trade-offs. So the house would have to be wider at the base in order to allow for a roof structure that came into the second floor living space. So you could not have a 16-foot wide house and make the second floor usable in a story and a half configuration. And okay, so if one were to design a story and a half configuration, it might look something like this. You see the second floor space above here, which is in the roof structure or partially within the roof structure, and the ground floor space, which could be smaller. In this particular instance, the house is 51 feet wide at the base, and it has overhangs of 2.5 feet on either side. The east and west elevations shows the roof structure here with gable structures providing window space into the bedrooms. But again, the width of this building would be 18.5 feet wide. And so the question has to be asked, if this was a better design, then would the ZBA prefer less corner side yard and a greater variance of the corner side yard in order to accommodate a wider house?
May I ask you a question? Because these are just new hypotheticals. But in responding to your neighbors, did you consider or would you consider developing a house on the property that is much more modest in size and consistent with the size of the other houses on those blocks?
So the answer is I would consider something like this. But I believe that a 3-bedroom, 2-bath house with that space on the second floor is essential, and I will address why.
Would you consider building a house that's smaller than 3 bedrooms, 2 bathrooms on that lot?
No.
Thank you.
To clarify, then, the alternatives that we're looking at here then have a similar total square footage in different configurations?
Yes.
Okay, very
Yes,
good.
it does. Yes, it does. But the height is less, the vertical bulk is less. And here's a comparison of the east elevation with the 1.5-story configuration versus the proposed configuration. And
These plans don't alter the setbacks, though, do they?
oh, they have different setbacks. Yes, they have different
So
setbacks.
it's wider, so the setbacks would be smaller, in fact.
Well, yeah, and on this alternate plan here, this would be 1.5 foot corner side yard versus a 4-foot corner side yard. The front canopy projects here. This plan here has a recess entry, so there's no projection. Some differences.
Right, but that does not address the concerns that the neighbors have presented to you.
I think it addresses, to a modest degree, some of the concerns. For example, this house extends further back on the lot than this house, as you can see, comparing it to the house to the south. So, and it also, I think there was some concern about the height of the structure. Okay? So, as I said, I am open to reasonable designs that provide for a usable house that meets today's demand for a livable house.
I have a question. Are you taking back your proposed square footage house and giving us this alternative plan now? Is that what you're doing?
Well, I can't really do that because this hasn't been reviewed by the city staff. They haven't looked at it in terms of the total variations requested. I throw it out there as a point of comparison, and if members of the ZBA indicated a preference for this kind of thing that made a difference, I'd be willing to modify the design and come back.
Let me ask another question. At the last meeting, you told us you held a community meeting with the neighbors at which you presented 3 plans, and we saw them last week.
Right.
This alternate plan is not one of those, correct? This is something new?
It is not one of those.
Okay. And so this alternate plan is an attempt you made in the last week to design something that you felt was responsive to the neighbors' concerns?
Well, actually, it was in response to a question by Mr. Kirill.
It's a difficult name.
Where he said, did you consider 1.5 stories? And I said, no, because, it's not wide enough to consider 1.5 stories. And if you maintain a 16-foot width, it's not wide enough. But so the question is, what's more important here? Is it minimizing the yard variances, or is it, reducing the vertical bulk of the building? So if more latitude would be granted in terms of, say, the corner side yard, and frankly, I'd be willing to ask the city if I could pour a new sidewalk that's 2 feet further in, so that there would be green space in front of the building, even though there's not actually an increase in the yard, technically. That is a creative possibility. Would result in a green strip along Reese that's only 1 foot less than the green strip along.
Just to be clear, you're talking about potentially asking the city that you would pay to re-pour the sidewalk
Yes, right here.
to reduce the right-of-way, to reduce the parkway depth, to give
Reduce the yes.
appearance of the house being further
Well, yeah,
set back.
to use the green space that's there instead of being between the sidewalk and the curb, it would be 2 feet would be placed between the right-of-way line and the sidewalk.
Okay, thank you.
Are you talking about doing that for the entire block or just in front of your house?
I think it would be only needed and only beneficial in front of the house, but it's 133 feet of length.
Okay.
And it would jog back at the it's only 2 feet. I'm only talking about 2 feet. So the second floor plan, obviously one has to look and make sure that it works. It would be 14.6 on the second floor instead of 18.6 on the first floor, so you'd have to step it back in order to place some of the livable space underneath the roof structure. And so that's how you get the reduction in bulk vertically. But the second floor space would work. 3 bedrooms, 2 bath. Again, not huge bedrooms, but serviceable. I don't have a walk-in closet. I don't have a big master, but those are compromises that, I'd be willing to make. So impact on value to adjoining property. So there's been a number of comments by neighbors indicating that they think it would have a negative impact on the value of their property. Obviously, if they don't like the idea of building on the lot and don't want to look at a house there, they're likely to think that it would impact their property values. I thought, frankly, the opposite, that with a higher value new home on the block, it would support property values, and because none of the conditions that I'm proposing for this property are unique to the neighborhood, they all exist on other non-conforming corner lots, that there is not a new standard being set here by this house that is below that already existing in the neighborhood. But that was just my opinion. So I did reach out to an appraiser and asked for an opinion on value, which you have a copy of that letter, I believe.
Is your appraiser here tonight?
He's not here tonight.
Okay. Is there, other than the 2-page letter and the qualifications and certification of your agreement, is there any other documents from your appraiser that weigh on his opinion?
Well, not documents per se, but if you read the letter, he considered...
The letter is it from your appraiser,
yes, the letter
right?
is it.
Okay.
Letter is it.
There's no appraisal in the letter, right?
There's not an appraisal, no.
The letter actually concludes, your appraiser, quote, have not inspected the property that is the subject of this assignment, right?
He has not physically been on site, but he has looked at it digitally, and he's looked at the evidence that I presented in my presentation.
Okay, so there's no opinion in here about the value of this property or the value of the adjoining properties?
It is not an appraisal of property value, it's an opinion on impact. So there would not be...
Where's the opinion in here on impact? Where does it say anything about the impact? Because I skimmed through it, but I didn't see anything about the impact on the neighbors.
I'd have to look at it and read it. I did
What's
read
your
it.
evidence? If you could point me to it. I didn't see it. All I saw was a conclusion that it meets the intent of the zoning ordinance. Are you referring to conclusion D on the second page?
Yes.
Okay. But without having looked at the market value of this home or the adjoining homes, how can we conclude what impact it would have at all?
He doesn't say that he hasn't looked at the values of property. He hasn't done an appraisal.
He hasn't cited the value of this property or any other property in the neighborhood.
That doesn't mean he hasn't looked at documents.
We can't ask him because he's not here.
This letter says that the appraiser is not offering a value of the property. He is simply saying that the proposed development has no adverse impact, in his opinion, on the adverse impact on the value of the neighbors' properties. So, I think that is just a generalization that your appraiser has made in his letter based on square footages of new homes and what they go for in Evanston, et cetera, and is not addressing what we have seen in the outpouring here of the particular aspects and character of this neighborhood that would be adversely impacted by the home. So that it's those very peculiar characteristics that I think Scott is referring to, that your appraiser has not really been able to evaluate because he hasn't made an inspection of the neighborhood or had a chance to hear this testimony.
Well, I believe the letter says that he has conducted a reconnaissance of the neighborhood via Google Earth and other satellite technology, and has ascertained that the conditions I'm proposing on this property exist elsewhere in the neighborhood. Okay, so in terms of these being peculiar and unique, they're not peculiar and unique. The setbacks that I'm proposing exist on other corner lots. The height of my building exists on other corner lots. The positioning of my garage exists as well on other corner lots. So
Those are your arguments, though. Those aren't any arguments that your appraiser has made.
well, the appraiser has said that he has looked at conditions in the neighborhood.
But we're just given a conclusion. So in my profession, expert testimony doesn't really have value if it's just a conclusion without giving the bases for the conclusion, the assumptions that underlie the bases, et cetera.
You know, I'm not going to argue with you. If you don't want to accept this as an expert opinion, but frankly would rather accept the neighbors' opinions.
I accept it as a letter you obtained to respond to the neighbors' concerns.
Okay.
Can I ask you a question?
Yes.
In speaking about the value of the property, when you purchased the lot, did you have a Phase 1 done?
I did not have a Phase 1 done.
Okay.
No.
So you don't know if the subsoil is contaminated, or if there might be a major remediation necessary.
You know, I wouldn't. Usually that kind of condition would have surfaced at some point in time over the history of the property. So the fact that it's only surfacing now, I mean, for other vacant lots I have purchased, I never had a Phase 1 done.
Well, in commercial areas, it's not atypical if there have been businesses that might have had hazardous materials to conduct a Phase 1. But I'm asking simply to know if you have any idea, in fact, what the condition of the subsoil is.
I've not heard of anything prior to tonight that would suggest that it was anything but a vacant piece of land.
Okay, thanks.
So there's a question by a member of the ZBA who asked when the properties referenced in my presentation were built. Based on data from the MLS, these are the dates built of the following properties. There are certainly other properties that were built subsequent to the establishment of the Evanston zoning ordinance in 1921. Pictured here is 3003 Park Place, which is on a corner lot of similar size to mine that was built in 1950. Obviously, there was an accommodation made for that property to build this two-story house on that lot. And I believe there were other accommodations made, certainly in terms of expanding non-conforming structures, adding a second story to a non-conforming structure, and other accommodations made on corner lots similar to what I'm proposing.
For those on the board who weren't here, 3003 Park Place was a case before the ZBA. It was a 1.5-story house, and they came to us for a second floor variance, in addition to some other variances to increase the size of the house. And we denied the increases to the size of the house. And as is our current standard, right, we approved the extension of second floor walls. So that house was not built as a 2-story house. It was built as a 1.5-story house, and then got a variance later based on changes to zoning from 1950 to 1993.
But it was originally built in 1950. It would have gotten relief from the street side yard requirement at a minimum.
As a 1.5-story house.
As a 1.5-story house, yes. So much has been talked about building a smaller house on the property, and frankly, there's a lot of risk attached to building any house on spec in Evanston or anywhere else for that matter. And so, it's very easy to say that, well, just build a smaller house. However, one has to weigh the risks and determine if, such a proposal would be financially feasible, and what's the evidence for that. So, one of the attractions of a 2-bedroom, 1-bath house is a lower sales price. And I'd like to submit this printout from the MLS, which looks at recently sold two-bedroom, one-bath houses in the area, and one can see that the closing price varies between $260,000 and $350,000. So
I'm going to mark that as applicant's exhibit. I think we're on 4, so I'm just going to go with that.
however, to build a new house of that size, you're going to be at a much higher price point, and yet competing with smaller, older homes that have a much lower sales price. And so it is really not feasible to build a smaller house that's going to be a much higher price point that compares with older homes in the area.
Can I ask you a question about some of these houses that have closed? Are you familiar with the condition of the houses?
Interior condition? No.
Yes. No. Okay. So when these houses are closing at $260,000 or $285,000, you don't know if they have an updated bathroom or an updated kitchen or new double pane windows or full insulation, all the amenities that your house would have that these may not have by virtue of not having been remodeled.
I'm presuming that many of them don't have.
Right.
That.
Okay. So then the value of the houses that you're giving us is not really comparable to the product you would be providing.
It would be comparable in terms of the program.
Yes,
Bedrooms, baths.
yes, but not condition.
Condition may be different.
And condition certainly has a major impact on the price of a product.
It has an impact. I think,
I think a full height basement versus a 6-foot deep basement is a major impact. I think having energy efficiency versus non is a major impact.
Yeah. Do you want to?
Additionally, if I can just point out to you, I wish that it were not so, but price of homes per square foot, for example, in southeast Evanston, where I live, are considerably lower per square foot than they are in northwest Evanston, where your home is proposed. So I think that you really, if you're going to give us comparables, then need to be comparing apples to apples.
You know, what I would say is that new construction price is very much less than resale prices, because the cost structure of new construction is going to be the same in northwest Evanston as South Evanston. Okay, 2x4 costs the same in South Evanston as it does in northwest Evanston. The only variable is really the price of the land, which typically is...
And the price that it will sell for in the marketplace as well.
Obviously, sellers try to get as much as they can for the product that they build, but if you look at square foot prices for new construction in South Evanston versus North Evanston, the range of price would be much different than resale because the cost structure is built in. In terms of the feasibility of building a new two-bedroom house, I asked my real estate broker to search the MLS records for new two-bedroom houses built in Evanston in the last 10 years, and there was not one. Not one new two-bedroom house built in Evanston in the last 10 years.
That could be because, as you pointed out at the last meeting, there are no vacant lots.
Oh, there are vacant lots.
Not of this size.
What difference does it make?
That was your
what
testimony
size it
at the
is?
last meeting.
Huh?
Well, it's because the size of the lot dictates
you're
what's
not
appropriate for the
constrained
lot.
by zoning to build a two-bedroom house. So if you're not constrained by
That's
the city
right.
to build a two-bedroom house, you never would.
The constraints are created in some ways by the size of the lot. Not every lot is appropriate to build a six-bedroom, 5-bathroom house. Some lots are, some lots aren't.
But there are other lots in this neighborhood on corner lots where houses of the size I'm proposing are built, that exist, and were allowed by the city of Evanston. Okay? So what I'm seeking is a house that's about 1,700 square feet in size, give or take, certainly less than 1,800 square feet on 2 floors, first floor, second floor. And I have built one such home. It's at 623 Oakton on a 25-foot wide lot. that I needed no variances for because it was an interior lot and was in the R5 zoning category. Okay, so I do know how to design and build an attractive, smaller house, and this is one such house. The original buyers are still the occupants, works very nicely, and this is the kind of house I'm proposing to build here. So
how many square feet is that 623 Oakton house?
Pardon me?
Square footage on that house?
It's in the range of 1,700 square feet.
1,700.
Yes. Okay. That's first floor, second floor. So in terms of impact on local flooding, so there have been a number of comments that homes in the areas at some time or another experience flooding due to heavy rains. And that this should be a reason for denying this petition. And I would say that for many years now, the City of Evanston has required grading plans as part of new home construction that ensures that the house will be built so that it facilitates drainage off the property and does not direct runoff onto adjacent property. The city's review works very well. I've built 22 houses. I've not had one complaint from either a buyer or an adjacent owner that the house I built impacted their property. Now, if certain older homes that were built before the requirement of grading plans exist and they either take on off-site water due to poor grading, poor drainage, or their house doesn't drain, frankly, it's because they are inadequately graded. And it's not because the property elsewhere on the block diverts water onto their property. So the presence of inadequate drainage on older homes that were built before grading plans were required should not be a basis for denying this petition. And my property will not have any material impact on the drainage or the flooding of other property. My runoff will be directed onto the site, and surplus runoff will go into the city sewers where it belongs. So,
before you give your summary, one issue that was weighing on my mind a lot after the last meeting, and I heard it reiterated tonight, but you haven't addressed it, is the proximity of that garage in the alley to the corner and the sidewalk and the safety issue that it potentially presents. Have you given any thought to that or come up with any solution or not?
The width of the lot is a major constraint. So I've conformed to the 3-foot interior side yard. The street side yard is not conforming 3 feet. If we're talking about a site triangle, essentially, one kind of mitigating proposal would be to increase the setback off the alley so that there is more sight. Triangle from the alley onto the sidewalk and onto the street. So I would be willing to do that up to a point, to increase the sight distance between the garage and the sidewalk. So I think back to basics here. The city has stated, they're on record as saying that a house should be built on this property, that is not an unbuildable lot. So it's a question of whether this proposal is reasonable in terms of minimizing the number of variances asked for and the degree of variance that's being sought. I would suggest that this is a balanced approach. It is a much smaller house, requires much less variance than the prior application on this particular property. It is not inconsistent with other existing homes on corner lots within this neighborhood. The house will not have an adverse impact on the adjoining property, and the zoning ordinance defines this as the single adjoining property to the south. I would say that it also has no impact on other nearby properties as well. The city has allowed the expansion, the building and the expansion of other non-conforming structures and on other non-conforming lots. It is frankly unfair to hold this property to a higher standard than that you've held other properties to. I would like to add one point here, which was this question of public benefit. And I believe I heard testimony from the neighbors make reference to the standards for public benefit of a planned development. Is that correct?
Yeah, you don't have to meet those, but it's really
And
it's
variance
really
is not held to the same standard as
as a public
the planned development.
As a planned development,
in
that
terms
is
of public
correct.
benefit.
However, the standards for major variations number 5 is B, that there should be a public benefit, and it's based on the table that I don't have.
Okay. Melissa, can you cite those? I don't want to neglect addressing that point.
Yeah, I got nothing. I told you I only had half of them.
Can I ask, is the point
I
of
take it back.
the point of your wanting this precise information is because you are claiming that you should not be required to provide any public benefit? Is that it?
I want to understand what the requirement for public benefit is when seeking a major variance.
I see. Okay.
I would say that one of the public benefits is frankly reinvestment in property. If nobody reinvested in property, the neighborhood and the city would go downhill. I happen to live in a neighborhood that has received very much needed reinvestment in property. Frankly, something that I started years ago, brought 9 new homes with homeowners into an area that frankly needed home ownership, needed reinvestment. Recently, we had 5 new homes built with a top value of about $700,000 in an area that when I first started, you couldn't sell a home for $200,000. And I bought a home to build a new house for $65,000. You know, there was an existing house on the property. So
It turns out I do happen to have the
Okay.
public benefits, so...
Could you please read them
want me
so
to
I can
run through
respond to
them?
them? Well, you said there were 3 of them?
No, there are actually 7.
For major variances that relate to...
8.
That relate to major
8
variances.
public benefit alternative to standard 5, yes.
Okay.
So A is the preservation and enhancement of desirable site characteristics in open space. B is a pattern of development which preserves natural vegetation, topographic, and geological features. C, preservation and enhancement of historic and natural resources that significantly contribute to the character of the city. D, use of design, landscape, or architectural features to create a pleasing environment or other special development features. E, provision of a variety of housing types in accordance with the city's housing goals. F, elimination of a blighted structure or incompatible uses through redevelopment or rehabilitation. G, business, commercial, and manufacturing development to enhance the local economy and strengthen the tax base. And H, the efficient use of the land resulting in a more economic network of utilities, streets, schools, public grounds, buildings, and other facilities.
And can I just verify that those are standards not for planned
Yes.
developments, but for
They absolutely
Major
are public
variations.
benefit alternatives to standard number 5 of standards of major variations.
To clarify, Chair Burns, the applicant, the code section 63-63 is referenced within the standards for major variations. That 6363 is found within the plan development section.
Okay, so it's a cross-reference back
It's a cross-reference there. It does state in that section that the public benefits include but are not limited to any of the standards in 6363.
Okay. So what I would say is that the public benefit would include the reinvestment in property, the elimination of a vacant lot, and a dark corner in the neighborhood, that there would be an attractive house built that would enhance property values, that there will be attractive landscaping, that there will be night lighting on the property that will improve frankly, walkability and safety in the neighborhood, and that this is an innovative design that provides for a quality house, an attractive house, with the minimum variation needed on a challenging lot. So, and it provides public benefit in the form of property taxes to support schools and city government.
Thank you.
Lastly, there's been a lot of testimony. Obviously, the preponderance of the neighbors who come out oppose things. They don't often speak in favor of things. I would ask that the ZBA hear this on its merits and strictly on the standards for variation that are presented in the zoning ordinance. There is no reference to neighbor objection in the variances, the standards for variance. Frankly, I'm working with an ordinance now that does make reference to neighborhood opposition, such that if there's opposing neighbors, then it requires a supermajority vote. But this is only for rezoning, not for variations. So, but your ordinance doesn't speak at all to neighbor opposition, and I don't think that is a direct, frankly, consideration in this on the technical merits. So I guess that concludes my closing comments. I'm available for any additional questions you may have.
Thank you. Were there any other questions from the board for the applicant?
No.
Nope. 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 No. No. Okay. All right. With that, we will close the record and go into deliberations. So thoughts from the board?
One thing that I will say is that there was a lot of reference to this should be zoned R2, and that if it was zoned R2, you wouldn't have to request the major variances that you are requesting. But in fact, it is zoned R1, and I think that part of the zoning plan in putting this area in that zoning designation is that they are single-family homes, and I think that there is a special quality that is expected in an R1 neighborhood that we've seen exhibited here. Basically, is that people form a neighborhood, a community, and the R1 zoning designation fosters that. It's a little bit different than the higher density that you would see in an R2 or an R5 neighborhood. And so I think that it is important. Although you don't want us to consider the testimony of the neighbors or their perception that this is impacting their values and their enjoyment of their neighborhood in a negative manner, we would be irresponsible to do anything less. Because that is part of what the impact of value is. Value is not just the resale price of their properties, but their current enjoyment of their properties and their ongoing enjoyment of their neighborhood overall. So that's the problem I have. It is R1. I do think that if the neighbors were presented with a sweet starter home that would draw to their community somebody that would have their same sensibilities, that's a saleable property, and that would be something that they have stated they would not object to. So I think that those voices have to be considered.
Those were good points. Just in thinking about some of the standards themselves, the applicant's summary is that the proposed house would not impact the value of the adjoining property or nearby properties. The standard, as I pointed out last week, is that the variation would not have a substantial adverse impact on the use, enjoyment, or property values of adjoining properties. I've been on the zoning board for 8 years. I can only think of 1 or 2 cases that had a larger turnout of negative feedback for the project from the neighbors than this one. I think that cumulative testimony is the opinion of the neighbors that this project would adversely affect, if not their property values, then certainly their use and enjoyment of their properties. Between the long, quote-unquote, wall that one neighbor referred to, he would see as he looked down the otherwise clear parkway of yards. Certainly the safety aspect, I think, is concerning and has a concern about the value in the neighborhood. So I don't know of a way that I could find that that standard technically has been met. I also have a problem with the standards that are tied to the hardship. I do think this is a very small piece of land, and the size of the land presents a form of hardship generally to development. That said, I think there is a way to develop the land with what's been described as a starter home. It certainly wouldn't net you the profit that you're looking for with your current project, but really the hardship you're talking about in your application is entirely created by the ambition of the project you're trying to build. It's the size of the building that creates the scope of the variations you need, that creates the need for you to locate the property as close as you have to the sidewalk, that causes you to have to seek building lot coverage variations, whereas a smaller starter home certainly at a minimum might not need that variation. So the standards that are tied to hardship, that are tied to the person having an interest in the property, and certainly that are tied to the applicant's desire to profit from the project as opposed to whatever public benefit you believe it's created. I don't believe any of those standards are met. I do think there is a reason you were able to acquire an empty lot in Evanston for $75,000. It is a lower valued piece of property for a reason. It's a smaller piece of property that requires a less ambitious development on it. And while I think the house you've designed is a very nice looking house and would have a great place somewhere in Evanston perhaps, I don't think it's on this lot.
Lisa, any thoughts?
I'll hold my comments.
Okay. How about this end?
I agree with you, Scott. I agree with you that the public benefit standard has not been met, and I also agree that enjoyment is in the eye of the beholder. The neighbors will not issue any enjoyment from the building of this house, so I disagree with this proposal. However, I still want to ask, there has been many references during this presentation to alternative plans, not that they were different in square footage or anything, but is that what we're to consider? Because I keep reading on his stuff that it says if we don't agree with it, that he would present an alternative plan, but that's not what he's presenting here tonight. It's the plan that we got last week, period, right? I just wanted to be clear. Thank you.
So here is my thinking. I would disagree with some of the comments that this lot is unbuildable. It is buildable. And it is buildable with variances, that's for sure. Otherwise, it's not. So I think that at some point of time, this board and the zoning administrator, we will have to make a decision about the variances that are applicable to this lot. So following this line of thoughts, I would say that variances are inevitable, but then the applicant has to show how he will be using these variances with the building that will be built on the lot. And I think that in this regard, the proof is not sufficient in my opinion. The building that is proposed uses the variances and after that proposes a volume of a building as if there are no variances. So this is the problem that I'm facing with the proposed development. I really am pleased that the applicant starts thinking a little bit in the direction of a smaller building, probably with less number and extent of variances, which I would not say that this is the variances I need to be well understood. I don't think that the variances are imperative here. I think that the result, the architectural product, is imperative in this case. It has to be in compliance with the surrounding neighborhood. It has to have its own architectural value. How it will be developed inside, how much square footage it will have, and how many bedrooms or bathrooms inside. This is something that has to be developed by the applicant, by the architect that works with him. But I definitely think that the proposed building as a proof for the requested variances doesn't do the job, simply because it is really large, really, I would say, imposing on the lot and on the neighborhood. Technically speaking, I'm having problems with our standards number 1, 5, and 7. These are the things that I reviewed, and I think that there is no proof that these standards are met. So this is my opinion, and I would encourage the applicant to provide a better solution for this lot.
Thank you.
Thank you.
I agree with many of the comments presented by Scott and by Carol, and I would commend Mr. James on the very extensive presentation and your consideration of the comments that you heard last week of both the zoning board and the neighbors, and certainly in meeting early on with the neighbors. It's clear that you have been working very diligently in trying to develop this lot. That said, I would agree in considering the way we have to view major variations and looking at the standards that have to be met. I also take issue with the standards that Carol mentioned in 1, 5, and 7. In particular, in looking at number 7, I don't think this is the least deviation from the applicable regulations that have been considered, that should be considered for this lot. I think obviously this is a problem site, and when we're starting to shoehorn a building on there that requires us to consider moving the sidewalk further into the public walkway is a clear flag in my mind that the building perhaps is too large, and so I would have I have difficulty in saying that the proposed what's been proposed before us meets these standards for a major variation.
Thank you. Again, to be brief, because we've all had so much fun with this. I generally agree with what has been said by my colleagues here. They've made excellent arguments. The two components that I will just add to are, as an architect, I firmly believe more strongly than anybody else here on this board in the benefits of zoning and the reasons we have the side yard setbacks and the reason we have street side yard setbacks and the reason we have front yard setbacks. And so when you set up those walls, essentially, right, of a front yard setback going down the street and of a street side yard setback that goes down the street, I think it's incredibly important to the neighborhood to respect those, and that those lines be held as closely as possible to what's existing on that street. So something that is more in keeping, a variance for the street side yard that is more in keeping with what is directly to the west and directly to the east is, in my mind, more appropriate for the neighborhood and more appropriate for the development of the lot. I also, if you've ever watched a zoning board hearing with me, the number 7 is one of the other big concerns of mine, is that these variances be limited to the least deviation necessary. And I do believe that there are changes to the plan that can be made that have fewer deviations and require fewer variances or less variances, and those sorts of things. So, with that being said, we're going to go through the 7 standards of variation for a major variation. Feel free to jump in anytime you want to add, feel that I've missed something, or you disagree with me. All right, number 1, the requested variation will not have a substantial adverse impact on the use, enjoyment, or property values of adjoining properties. We've had testimony from the neighbors that, and quite frankly, a lot of neighbors, more than we've seen in almost any other case, that there will be adverse impact on their use and enjoyment. And now, although that is not a defining standard for having this condition not be met, it certainly is an important one to be considered. I do think that having such a large footprint on such a small lot does have an impact in the neighborhood. So I believe that standard has not been met.
I agree, but I would also add, I think there's also been testimony that the impact could extend to safety and or potential flooding problems, which I agree with the applicant. You can't point to flooding problems on a separate lot as a reason to deny the variation. However, when the applicant is seeking to expand on the lot coverage when there already is testimony of flooding problems in the neighborhood, that's certainly something to consider.
Thank you.
Also, I want to add the health considerations that were brought up at this meeting.
Thank you. Number 2, the requested variation is in keeping with the intent of the zoning ordinance. So the intent of the zoning ordinance is to allow for development and to allow for expansion of your house in keeping with the general characteristics of the neighborhood and of the city as a whole. And in this particular instance, I think that the massing of the house and the location of it as so close to the street side yard does not keep within the intent of the zoning ordinance. So I do believe that standard has not been met. Number 3, the alleged hardship or practical difficulty is peculiar to the property. We do know that this is a platted lot, and with the required side yards, it is only 5 feet wide of buildable area. So I do believe that there is a peculiarity to this lot, so the standard has been met. Number 4, the property owner would suffer a particular hardship or practical...
Sorry, just
Yep.
on that one.
Yep.
I agree that the standard is met in a vacuum with respect to the property, but I think the extent of the hardship is created by the applicant in this case.
Right. Based upon your comments from earlier. Number 4, the property owner would suffer a particular hardship or practical difficulty as distinguished from a mere inconvenience if the strict letter of the regulations were to be carried out. I think that there is a hardship and a practical difficulty if we try to limit this to being a 5 foot wide buildable lot. I think that is inconceivable, and we can all agree that that's sort of ludicrous. So I do believe that standard has been met. Number 5, the purpose of the variation is not based exclusively upon a desire to extract additional income from the property, but does provide some public benefit. And so we've talked at length about this, and in fact, I was quoted to myself saying that we, of course, regularly hear from developers whose sole goal is to make a profit. And I take that back. It's not their sole goal, but their primary goal is to make a profit. But from those projects, we generally have a side benefit. And it's usually in the form of taking a blighted structure or something that is too difficult for a regular homeowner to handle and to be able to modify that. For somebody, it's a project that needs somebody with a little bit more sophistication and some more resources to be able to handle those things. And so those are some of the benefits that we see here. We see in a typical development. Unfortunately, for me, I don't see that there is a public benefit in this particular instance. one of the reasons I don't see that is because the neighborhood is so against the piece of property. I don't think that there is that the neighborhood sees a public benefit. Additionally, we're not getting rid of a house. We're not getting rid of a structure that is deteriorated. We're not getting rid of a structure that is full of lead and a hazard to live in. So I don't think that standard has been met. Number 6, the alleged difficulty or hardship has not been created by any person having an interest in the property. Again, from a strict reading of this, the property was platted long before you purchased it. And so the land is what the land is. And so I do believe that standard has been met.
I'll just disagree for the same reasons stated before.
Great, thank you. Number 7, the requested variation requires the least deviation from the applicable regulation among the feasible options identified before the Zoning Board of Appeals issues its decision or recommendation to the City Council regarding said variation. There's been a lot of discussion about the size of this project and the required variances based upon that size. I certainly think that there is room for this project to certainly get smaller. And quite frankly, I think that it should be a one-car garage because I think that 10-foot sight triangle at that corner is critical. And I think that that's probably a variance that would be gettable given that argument because that's a pretty darn good argument. That's right up there with stairs and headroom at stairs and life safety and all that good stuff. So that was my little piece on the side. But so I think that the bulk of what's being asked is not the minimum change necessary. So I do not believe that standard has been met. With that, can I have a motion in the affirmative, please? Yeah, remember? We do motions in the affirmative. What do you mean, what does that imply?
If someone makes a motion to approve the case, you are still able to vote
no
in either direction.
Or yes, however you should like. And if nobody wants to make it, I'll make it. Okay, am I making it? All right. Unfortunately, I don't have the documents. Thank you. All right. In the matter ZBA 17ZMJV-00772626 Reese Avenue, I move that we approve the variances requested by the applicant.
I second your affirmative motion.
Thank you. It's been moved and seconded. All those in favor say aye. All those opposed, nay.
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 With a vote of 0 to 6, unfortunately, your project has been denied. Thank you very much, everyone, for coming out. I appreciate your, No, I recommend that you coordinate with Melissa after the fact. Tomorrow, give her a call, and she'll be able to help you out. So thank you, everyone, for participating. I appreciate everyone's time and energy.
I move to adjourn.
Second.
It's been moved and seconded. All those in favor say aye.
Aye.
All opposed? And with that, we are adjourned.